At the exact moment Judge Barl Howell slammed her gavel and ordered the room into silence, Congresswoman Jasmine Crockett didn't back down. She looked straight at the bench, delivered a single line that shattered the courtroom's balance of power, triggered national outrage, and ignited a political firestorm that forced America to ask a dangerous question. Was a federal judge protecting the law or trying to bury the Constitution? The federal courtroom looked calm on the surface, but everyone inside could feel the pressure building. The benches were packed shoulder to shoulder. Reporters filled the back rows. Civil rights advocates sat stiff and alert, eyes locked forward. At the center of it all sat Judge Barl Howell, upright behind the bench, gavel resting near her hand like a warning sign. People in this room knew her reputation. She ran a tight courtroom. No rambling, no drama, no patience for what she called performative lawyering. The case itself was simple to explain, but explosive in impact. New election rules had been passed under the banner of security. Supporters said they would protect ballots and prevent fraud. Critics said they would block real voters, especially seniors, low-income communities, and minorities. Judge Howell adjusted in her chair and glanced down at the docket. Her face was unreadable, but her posture sent a clear message. This was not going to be a soft hearing. When Crockett's name was called, the room went still. Crockett stepped forward and took her place at the podium. She stood straight, eyes forward, waiting for permission to begin. The judge nodded once, sharp and brief. But before Crockett could fully settle into her opening, Judge Howell spoke first. Her voice was calm, but firm enough to cut through the room. "Congresswoman Crockett," she said, "this court will not be used as a political stage. Stick to the law." The message was clear. This was a warning shot, a line drawn before Crockett had even opened her mouth. But Crockett didn't flinch. She didn't argue back yet. She simply lifted her folder, placed it flat on the podium, and took a slow breath. Then she looked up at the bench, steady and controlled. Then Crockett cleared her throat and finally began to speak. Her voice was calm, steady, and controlled. The kind of tone built for courtrooms, not campaign rallies. "Your Honor," she started, "this case goes to the heart of equal access to the ballot." She didn't get to finish the sentence. Judge Howell leaned forward slightly, eyes narrowing. "This court does not entertain political speeches," she cut in. "Focus on the law." The words landed heavily. Crockett paused for half a second, not long enough to look unsure, just long enough to reset. Then she nodded once. "Understood, Your Honor," she said evenly. And without raising her voice or changing her posture, she pivoted. "Let's talk about the law." She laid out her argument in a clean, structured way, almost like she was drawing lines on a whiteboard. First, the Constitution. She pointed to the 14th Amendment and the principle of equal protection, explaining in plain language that voting rules cannot create unequal burdens across different communities. Second, the Voting Rights Act. She reminded the court that Congress designed it to stop not just obvious discrimination, but quiet systems that produce the same harmful results. Third, precedent. She referenced past Supreme Court rulings that made it clear states cannot hide behind administrative rules when those rules functionally block citizens from voting. It was tight, it was organized, and it was hard to dismiss as anything other than legal argument. Then Crockett did something that shifted the room. She reached into her folder and lifted a single sheet of paper. No thick binders, no dramatic stack, just one clean chart. "Your Honor," she said, holding it up slightly, "this is a county-by-county breakdown of early voting access before and after the new rules took effect." She explained what it showed in simple terms. Fewer polling locations in low-income districts, shorter early voting windows in heavily minority counties. A measurable spike in rejected IDs after the rule change. Numbers, not opinions. Data, not slogans. Then she made the move that mattered most. "I request that this exhibit be entered into the official record." For a brief moment, the courtroom froze again. Judge Howell glanced down at the document, then back up at Crockett. Her jaw tightened. Judge Howell didn't let the moment sit for long. As Crockett finished explaining the chart, the judge leaned forward again, her voice sharper this time, louder, cutting across the room. "This is a courtroom," she said, tapping the edge of the bench lightly. Not a history lecture. The tension tightened instantly. A few attorneys in the gallery exchanged quick looks. Civil rights advocates stiffened in their seats. Everyone could feel the line being drawn again. The judge wasn't just correcting procedure. She was pushing back, trying to pull control of the room back to her side. Crockett didn't argue with the tone. She didn't react emotionally. She simply turned one page in her folder. "Your Honor," she said calmly, "this is not history. This is sworn testimony." She lifted another document, thinner than the chart but heavier in impact. This is a declaration from a county poll worker who oversaw early voting operations after the new rules went into effect. Then she read two short lines, slowly, clearly, so they landed. "On the first day of early voting, we were instructed to turn away elderly voters whose IDs did not match updated database formatting." She paused. Then the second line. "Over 40 mail ballots were rejected in one afternoon due to new signature verification rules that were not explained to voters." The room went silent. No opinions, no speeches, just documented experience from someone who was actually on the ground. Crockett lowered the paper and looked back toward the bench. Her voice stayed even. "You asked for law, Your Honor. The law doesn't just test intent, it tests impact, and this is impact." It was a direct answer to the judge's demand, turned back with precision. She wasn't changing the subject. She was following the rules the judge had just laid down and doing it better than anyone expected. Judge Howell's expression tightened. Her fingers closed around the gavel, not striking it yet, but holding it like a signal. "Congresswoman," she warned, "watch your tone. You are approaching contempt." The threat hung in the air. This was the moment most people would pull back, apologize, soften their language. Crockett didn't. She didn't raise her voice. She didn't step back either. She simply nodded once, acknowledging the warning, and continued standing straight at the podium, calm and controlled. Judge Howell's patience finally snapped. She straightened in her chair, lifted her chin, and spoke with the full weight of the bench behind her. "Congresswoman Crockett," she said, slow and deliberate, "confine yourself to binding legal precedent, or you will be held in contempt of this court." The room went rigid. You could feel the cliff edge. Even the reporters seemed to freeze for a second, knowing this was no longer just tense. This was dangerous territory. One wrong move and Crockett could be publicly shut down, fined, or removed from the courtroom. Everyone waited to see if she would retreat. She didn't. Crockett inhaled once, steady and controlled, and then responded without emotion, without attitude, without raising her voice. "Very well, Your Honor," she said. "Let's talk precedent." And then she began stacking cases, one after another, like bricks forming a wall. "Brown versus Board of Education," she said, "established that equal protection is not symbolic. It is enforceable. Reynolds versus Sims made clear that the principle of one person, one vote is not optional, it is foundational. Harper versus Virginia Board of Elections confirmed that states cannot use administrative barriers to condition access to the ballot. But she didn't just list case names, she connected them. She built a straight line the room could follow. Equal protection leads to equal weight of votes. Equal weight of votes requires equal access to the polls. When new rules create barriers that fall harder on certain communities, that creates a disparate burden. And disparate burden is exactly what the Constitution was designed to stop. The gallery leaned in. This wasn't rhetoric. This was structure. This was law arranged in a way that was hard to poke holes in. Crockett wasn't defending herself anymore. She was building a framework the judge would have to confront. Then she made a move that caught the room off guard. Crockett looked up from her notes and spoke directly to the bench again. "Your Honor, for the record, I ask for clarification on the standard this court is applying." She paused just long enough to let the words sink in. "Is the court using strict scrutiny, given that this case involves a fundamental right or a balancing test that weighs state interests against voter impact?" Then the gavel came down hard. The sharp crack echoed through the courtroom and cut off every sound in the room. Judge Howell's voice followed immediately, louder now, no patience left to hide behind formality. "Enough," she said. "I will not allow this courtroom to become political theater." The words hit like a wall. The message was clear. This was the judge taking full control, trying to end the momentum, trying to remind everyone who held the power in this room. Crockett didn't rush to respond. She straightened her back slightly, lifted her chin just enough to meet the bench eye to eye, and let the silence stretch. The gallery stopped breathing. Reporters froze mid-typing. Even the judge's hand stayed resting on the gavel, unmoving. Crockett's voice finally came, low, steady, and controlled. No anger, no shaking, no theatrics. "Your Honor," she said calmly, "with all due respect, the Constitution does not end at your bench." For a split second, it felt like the room tilted. You could hear someone inhale sharply in the back row. A few people shifted in their seats. The words weren't shouted, but they landed heavier than any raised voice could have. Crockett didn't stop there. She repeated it, slower this time, making sure every syllable was clear. "The Constitution does not end at your bench." She wasn't being dramatic. She was being deliberate. She knew exactly what she was doing. That second repetition wasn't for the judge alone. It was for the court transcript, for the cameras, for every clip that would be shared later that night. Judge Howell didn't respond right away. Her mouth opened slightly, then closed. Her eyes stayed locked on Crockett, but the rhythm of the courtroom had changed. This wasn't a simple warning exchange anymore. Crockett hadn't insulted the judge. She hadn't broken decorum. But she had done something far more dangerous. She had reframed the entire power dynamic in one sentence. Not judge versus lawyer, not authority versus defiance, but principle versus position. Judge Howell rose from her chair so fast it scraped lightly against the floor. She pointed straight at Crockett, her voice sharp enough to cut through the room. "You will not lecture this court," she snapped. "You are here to answer questions, not grandstand." The room stiffened. You could feel the power move in real time, the judge trying to slam the door shut before Crockett could push any further. Crockett didn't step back. She didn't blink. Instead, she slowly raised one hand, palm open, not shaking, not aggressive, just firm. "One moment, Your Honor," she said calmly, but with steel underneath. "You don't get to silence constitutional arguments and call it order." A murmur rippled through the gallery. Crockett leaned slightly forward and added, "If protecting voting rights sounds uncomfortable in this room, maybe that says more about this room than about my argument." The judge's jaw tightened, but Crockett kept going, still controlled, still steady. "Respectfully, I'm not lecturing," she said, her tone low and deliberate. "I'm reminding this court of its job." She let that sit for a second, then pressed harder. "Congress is created in Article 1. The people elected us to protect their rights. Courts exist within that same Constitution, not above it." Her voice sharpened just enough to sting. "Authority doesn't mean immunity. It doesn't mean you get to brush off real harm and hide behind procedure." Then she delivered the line like a hammer strike. "Your robe is powerful because the Constitution is, not because you sit higher than the rest of us." A few gasps slipped out of the gallery before people could stop themselves. Crockett didn't slow down. She locked eyes with the bench and kept her voice steady, but ruthless in its clarity. "When this court cuts off arguments about voter suppression, you're not protecting efficiency," she said. "You're protecting silence, and silence is exactly how rights get erased." She paused, then added, "If this court wants to be remembered as neutral, it needs to start acting neutral. Not defensive, not dismissive. Neutral." The room felt like it was holding its breath. Even the reporters had stopped typing, afraid to miss the next line. Judge Howell stood frozen behind the bench, hands gripping the edge now instead of the gavel. Crockett stood there, unmoving, unshaken, daring the court to choose. The gavel came down again, louder than before. "Recess," Judge Howell snapped. And just like that, the spell broke. The courtroom exploded into motion. Reporters jumped from their seats, cameras swinging toward the aisle. Lawyers grabbed folders. Advocates whispered urgently into phones. What had been a frozen battlefield seconds earlier turned into controlled chaos. Crockett stepped away from the podium, but the energy followed her. She didn't rush. She didn't celebrate. She walked out steady, shoulders back, eyes forward, like someone who knew this fight had just moved into a bigger arena. The hallway outside the courtroom was already packed when she reached it. Microphones were shoved toward her face from every direction. Flashbulbs popped. Voices overlapped. Congresswoman Crockett, did you just accuse the judge of overreach? Are you challenging the authority of the court? Do you stand by what you said? Crockett stopped, turned slowly and faced the cameras. Her voice stayed calm, measured, controlled. I didn't accuse anyone of anything, she said. I defended the Constitution. That's my job. Then she added sharper this time. If that makes people uncomfortable, that's not my problem. The truth doesn't exist to protect egos. The clip was already being uploaded before she finished the sentence. Within minutes, the story stopped being about courtroom tension and started being about evidence. The viral clips didn't just show her iconic line. They zoomed in on the one-page chart with county-by-county voting cuts. They replayed her reading from the sworn declaration describing elderly voters being turned away and mail ballots rejected. They stitched together her precedent chain, showing how she tied constitutional law to real-world impact. Viewers weren't just watching a confrontation. They were watching receipts, hard numbers, official declarations, case law, and that made the story harder to dismiss as drama. Civil rights organizations move fast. The ACLU posted a statement praising Crockett for defending constitutional protections in real time. The NAACP called the moment a necessary stand against voter suppression tactics. Even legal groups that usually avoid controversy weighed in carefully, saying that vigorous advocacy and full constitutional arguments are essential to a fair judicial process. Those short statements poured fuel on the fire. This wasn't just social media noise anymore. Institutions were stepping in. At the same time, the backlash machine spun up. Complaints against Judge Howell flooded judicial oversight inboxes. Some people treated it like a victory, but Crockett shut that down quickly in a follow-up interview. This isn't about punishment, she said. This is about accountability. Let the record speak. Let the facts speak. That's all I've ever asked for. The stakes were clear. This wasn't cancel culture. This was pressure. Pressure on the system to answer hard questions in public. By nightfall, headlines were split down the middle. Some called Crockett a hero who stood up to judicial overreach. Others accused her of being disrespectful and reckless. But both sides shared the same clip, the same line, the same evidence. And that was the real twist. No matter where people landed, they were watching, arguing, reposting, and replaying the confrontation. The courtroom was empty now, but the fight had gone national. And there was no pulling it back inside those walls. The fallout didn't take days. It took hours. Legal commentators were already debating the judge's conduct on national television, replaying the footage frame by frame, analyzing tone, interruptions, and courtroom control. Op-eds hit the internet before sunrise, some defending Judge Howell's authority, others questioning her impartiality and restraint. Ethics experts started using words that made people uncomfortable: temperament, appearance of bias, judicial overreach. The judge's reputation didn't collapse, but it cracked. And once a crack appears in public trust, it doesn't disappear quietly. It spreads, it grows, and it forces institutions to respond whether they want to or not. While that storm was building, Crockett was already back at work. On Capitol Hill, she didn't soften. She didn't retreat. If anything, she became sharper. In hearings, when corporate executives dodged questions or tried to hide behind vague answers, she leaned forward and delivered a line that instantly went viral again. "I've already explained constitutional law to someone with a gavel," she said. "So don't insult this room by pretending you don't understand basic accountability." The message was clear. She wasn't bluffing. She wasn't posturing. She was signaling that the courtroom fight had changed how she played the game everywhere else. The ripple spread fast. Law schools broke down her courtroom strategy in real time, not as a speech, but as a case study in pressure, structure, and record building. Activist groups cut short clips of the confrontation into fundraising ads, pairing her words with images of long voting lines and rejected ballots. Donations jumped. Volunteer signups surged. The moment stopped belonging to one courtroom and started living in classrooms, town halls, and organizing meetings across the country. And that was the real win. Not applause, not headlines, not trending hashtags. The real win was that the country was forced to talk about the Constitution again, not as a museum piece, not as a slogan, but as something active, something that still had teeth. Authority was never the issue. Judges still had gavels. Lawmakers still had power. Institutions still stood tall. But Crockett's stand reminded people of something deeper. Authority without accountability is just noise. Power without responsibility is empty. When people look back on that day, they won't remember every legal argument or every procedural detail. They'll remember the moment someone refused to be quiet. They'll remember a courtroom that tried to shut a conversation down and instead sent it nationwide. Because that day wasn't about winning an argument. It was about refusing to let the Constitution be treated like a decoration. If this moment shocked you, inspired you, or made you think twice about who really holds power in this country, don't stay silent. Drop your thoughts in the comments and tell us where you stand. And if you want more real stories about power, accountability, and the moments that change history, make sure you subscribe, hit the notification bell, and join this community. Because here, we don't just watch history happen. We break it down, we question it, and we keep it alive.